Hello and welcome to MoLawNow. My name is Jessica Shumaker and I'm a staff reporter for Missouri Lawyers Media. Our guests today are St. Louis Circuit Judge David Mason and Paul Venker, an attorney with Baker Sterchi Cowden Rice in St. Louis. They are both part of a steering committee assembled to establish a new memorial in St. Louis that honors the nearly 400 freedom suits filed in St. Louis in the 57 years prior to the Civil War. During that time period, approximately 400 slaves sought their freedom in civil lawsuits under the doctrine of once free, always free. One of the most infamous U.S. Supreme Court rulings, Harriet and Dred Scott v. Sanford, started as a freedom suit. The memorial seeks to honor slaves, the lawyers who represented them, and judges. In 2016, the steering committee selected sculptor Preston Jackson to build the memorial, which will be located in the East Plaza of the Civil Courts building in St. Louis. Welcome, Judge Mason and Paul.
How are you doing?
First of all, Judge, could you tell us how this effort began?
Well, good Lord, we're about 7 or 8 years ago. Well, more than that, so I should start at the very beginning. Roughly 10 or 11 years ago, we found in our files, we meaning the 22nd Judicial Circuit, we found in our files that we had stored in the old Globe Democrat building. These old files, we were in the process of cleaning out things because we had to come out of the building, and these old files were discovered. When they were looked at closely, we saw that all of these suits, these freedom suits, their actual files have been preserved, the actual documents. This, of course, was a find of significant historical merit. Obviously, I, as a circuit judge, learned about this very early on. Now, consistent with learning about that, or contemporaneous with learning about that, I personally, as a trial advocacy professor and a trial lawyer, although I was a judge at the time, was really curious about what kind of arguments did the lawyer for the Scots make before this all white male jury of property owners, some of whom were likely to be slave owners. What kind of arguments were made to convince that jury to set Dred and Harry Scott free? I was just curious as to what kind of advocacy went into it. That caused me to not only start taking a close look at that, but also a closer look at the freedom suits themselves. After looking at it a lot closer, I began to realize that, number one, the slaves who filed these lawsuits were very courageous people. In most cases, they were taking significant risk. I began to wonder what happened to those who lost. It is not a pretty story, and I can elaborate on that later. And I begin to see in some of these files things like judges issuing orders of protection to make sure that the slave petitioners were not being harmed during the course of the lawsuit. I saw that there were, within the legal community, a number of lawyers who seriously took it upon themselves to use this not only as a vehicle to fight slavery, generally speaking, because St. Louis at the time was sort of half slave, half free, but also in some circles, it was kind of you could sort of raise your game as a lawyer if you fought these lawsuits and won. At least within certain aspects of the community of St. Louis, you could do that. And so, but at the same time, there were also losses if you went to court as a lawyer. You know, you were basically locking out a huge block of potential clients. So there were risks for the lawyers, maybe not as much for the judges. They did have to face being elected, but obviously the greater risk were for the slaves themselves. And I can go ahead and tell you now what they were facing. They could actually be killed if they were considered to still be property. They obviously, whipped and chained a lot. I mean, if you know anything about slavery, you know that's a problem. They could also be sold to the plantations, most notably in Mississippi and Louisiana. Now, these plantations had a national reputation, most especially Louisiana, for a culture of cruelty to slaves. If you ever read about how slaves were treated in and around New Orleans, you would be amazed at just how incredibly cruel humans can be. Uh, there are no horror movies that depict anything worse than what many slaves had to endure being in Louisiana, particularly if they had a reputation for being, an uppity slave who would actually have the nerve to file a lawsuit. That led to many slaves warning other slaves that, look, if you file this lawsuit, you're going to be sold down the river to Louisiana and Mississippi. And if you want to know the genius of the phrase being sold down the river, you have to do a lot of work to really see this. But actually, that's the genius of the phrase being sold down the river. Because as you know, phrases like that often rise from a factual aspect of culture or society. And the only place that you get to the fact of being sold down the river is what happened as punishment for slaves who filed lawsuits. And of course, as you know, in modern American vernacular, being sold down the river is in fact an indication that you are going to be punished. You are going to be harmed. And that's where the sold down the river comes from. It's that fear of being sold down the river if you lost your lawsuit. Now, so that being said, let's get back to your original question. That being said, I reached the conclusion that the city ought to honor this period. It was unique in America. It was an honorable thing for our courts to do. Uh, it actually was something that showed that even though slaves are at the lowest rung of society's ladder in this country, if there was a law that entitled them to relief, that they were going to be protected, the courthouse door would be open, and they could come in with their lawsuits and sue for their freedom. Now, why is that significant? When you consider the fact that in the slave states, generally speaking, people didn't even think of slaves as having any kind of real right at all. And the concept of a slave being able to drag a slave owner into court, I mean, it's literally the old phrase, gee, that's unheard of. It's just something that did not happen. And it literally shocked the conscience of many pro slavery people across this country. Uh, and so I felt that what we were doing in St. Louis, despite all the nasty things that can be said about the history of this country, this, in my view, was an oasis of right thinking, an oasis of liberty, an oasis of freedom that was being given to slaves. And so I started to talk to my colleagues, my fellow judges. They were all in agreement, enthusiastic agreement. Uh, they voted unanimously. And it's hard to get all 30 some odd of us to do anything unanimously. But they voted unanimously that we needed to have a memorial to honor this period on the East Plaza of the building. Thereafter, things got rolling. The lawyers that agreed to come in on the steering committee, Paul is first example, came in enthusiastically right away. Uh, then, of course, we went about the process of doing a national search for an artist. We could not have found, I think we all agree, a much better choice than Preston Jackson. Not only had Preston had been spending a part of his career honoring through his art the struggle of the American slave and American slave descendants, but he also had studied this before he sent his proposal and had become emotionally attached to uh, doing an art piece that honored this period. So when he came in, not only did he have a very interesting work, but as we listened to him in his interview, it was clear that this was literally a marriage made in heaven. And then we began the long, hard road to funding. Because just as you are listening and learning now, it isn't like walking up to, a group of people saying, hey, I want to get money to help Easter SEALs or the Boy Scouts or, things like that, where people instantaneously understand what you're asking your money for. This took some explaining because this was not really known in history. Lawyers would tell you when they discussed Dred Scott case in law school, it was looked upon as a one-off case. That some creative lawyers filed this lawsuit and it went up to the Supreme Court, et cetera, et cetera. It never was known that Dred Scott was, with all due respect to Dred and Harriet, the case that came along at the right time. The right time being just as the Missouri Supreme Court had stacked itself with anti-slavery people who were striking down these lawsuits, just as the United States Supreme Court had reached a 5-4 majority that was very, very, not anti-slavery, I'm sorry, pro-slavery, and that was also very, very pro-slavery, a group that was led by a person, Justice Taney, who was absolutely determined to put down this rebellion known as the Freedom Suit. If you're a lawyer, you understand that the Supreme Court only has a limited number of cases where they need to review an appeal. Most everything else is discretionary. And they tend to not take things where state law kind of resolves it. All right. This was a case when it was taken to the Supreme Court. Under normal standards, they should not have even taken it. The issue that arose is when the lawyers for the Scotts decided to go to federal court after they had lost in state court. They had won their jury trial in state court, but the Missouri Supreme Court knocked them out. So I said, well, let's go to federal court. And I don't think, I'm kind of glad that they forced the issue, but I don't think they saw this train that was coming, so to speak. They went to federal court and they won their federal trial, but the lawyers for the Sanfords came up with this argument that there was no standing in the first place, arguing that slaves cannot be citizens. Now, this particular argument hadn't really gained any ground before, but it gained some ground with the Court of Appeals, and it caught the attention, obviously, of Justice Taney. Certiorari was granted, and they took the case. Now, why do I use this language to make it sound like Justice Taney had ulterior motives? Because he basically wrote those motives in the ultimate opinion that we call the Dred Scott case. The Dred Scott case is interesting reading for anybody who wants to know where or what is the cultural basis for racism in America today. Justice Taney's book is better than any sociological study you can find. He lays it out for you. And what he does throughout the course of his very long opinion is he takes every negative rumor, unsupported belief that goes on in all of America about the Negro and writes it as if it were fact. I'm surprised he didn't add that we have tails, because he got about as close to that as you can get. And he goes on and on, saying all this stuff as if it were fact to justify his conclusion, mind you, as a Supreme Court judge, as a matter of law, the Negro is a divinely determined lesser species of human whose only purpose is to be subservient to the white man, but never equal, and therefore can never be equal in civil status. Since we can never be equal in civil status, that means we can never be a citizen, which of course means we can never go to any court, we can never have any rights affecting citizenship. And in fact, to be honest with you, he took it even below that, because his ultimate conclusion that the Negro has no rights to which the white man is bound to respect. Well, you know, a French person who's not a citizen who makes a contract in Louisiana to buy furs still has the right to sue on that contract against an American citizen that might be the other side. So our rights even went below the rights of foreigners who were doing business in the United States, who were in the United States for any reason. I mean, even foreigners could apply for citizenship. As far as Justice Taney was concerned, Negroes, slaves, and slave descendants, free or not, could not even apply for citizenship. See, I think I got a little bit away from your question, which is how this can. I started giving you a history lesson,
Yeah,
and I'm
you're
sorry
fine.
about that.
You're fine.
But sometimes I've learned that sometimes it's very important for people to understand the backstory.
Absolutely.
And so I may have gone a little too deep into the backstory for you. And I'm sorry about that.
You're fine.
So anyway, the committee, we find this outstanding artist. We start going down the road of educating people. Took a lot longer than I think we thought it would take. It wasn't for Paul's leadership. And Mr. Venker was assisted very strongly by former Mayor Francis Slay, former president of the Missouri Bar, Miss Lynn Ann Vogel. And they basically went about the business of trying to marshal the troops, particularly within the legal community. And again, it took a while. I dare say there were probably all of us who had moments of unexpressed concern, disappointment. We probably all had quiet moments of wondering, is this ever going to happen? But then along comes a former student of mine named Edward Herman. His occupation, he's one of the senior executive partners at a firm called Brown and Crouppen. But Ed had been a student of mine for 2 years, and Ed calls me about it and wants to offer his help. And the help that he was able to get for us was a company called Kufire Media. It's actually a very successful video and TV production firm here in town. He got them to agree to do a promotional video for us. They did the video. It was very well done. It got out very strong in social media, and it gave Lynn, Francis, and Paul some additional ammunition. And with that additional ammunition, they started turning the war around, to put it in that vernacular. And you will talk about, in the legal profession, we talk about rainmakers. So when you talk about rainmakers, these three, I am impressed and continue to be impressed, because they reach levels of fundraising that have essentially guaranteed this memorial is going to go up. So that's the story leading up to this moment.
Yeah. So my next question, I wanted to ask Paul, I don't know if you'd be willing to answer this, but what does the memorial look like? Can you describe it for us?
Well, the memorial is luckily has gotten even a little bigger than the initial vision that Preston Jackson's got for it. Right now, it's going to be about 14 feet tall, and it is what I've called in the past a dynamic visual narrative of the story and the vision that Preston has to tell about these freedom suits. And so it's really broken, and I think even more clearly so in the most recent version of the memorial, in two parts. One is the inside of the courtroom, where a woman who is clearly a slave is testifying for her freedom. And in the courtroom, of course, is the judge and a lawyer who is arguing on her behalf. And outside the courtroom, there are a number of scenes that Preston has put out for us to see that outside the courtroom, slavery still continues, as harsh as it is. And one of the little vignettes is a slave master who's clearly caught a slave who was trying to get away, and he has a billy club and he has a dog with him that clearly helped him find. We also have just a normal street scene who I assume are, white people, a family just walking down the street, free, able to enjoy society in the open without concerns. And so I think what this really does for us, the memorial, is if one can look at it and take it all in, can see, and even now with this recent refinement that Preston's done, where inside the courtroom there's a split between the slave who's testifying and the judge and the lawyer, because even there's clearly a split. There's all sorts of different things that we would never tolerate today. For example, slaves were not even really allowed to testify. The reason Preston did this is because women were most often the plaintiffs in these suits, because at the time, whether the child was free or slave was determined by what the mother was, a free or slave person. And so I think that was a great nod to women being a significant player in this role, this task of trying to get freedom. But even she is separated from the judge and the lawyer because it's not quite the same as if one of us, a white person at the time, were to go into a courthouse. Still not quite the same. And that's some of the harsh reality of this, too, is that we talk about them suing for their freedom. Well, they're really suing to be not a slave. Freedom, as we think of it, is a really different concept than what they were facing at the time. They were still not able to do a lot of things. They weren't even declared to be citizens until many years after the Civil War. It was quite a bit later. So 1868 was when they were finally declared to be citizens. And so there it is after the war. So anyhow, that's what I see in the memorial. And we hope, as part of the Learning Center for this, to have maybe even a video that people who go there could queue up and have maybe Preston Jackson provide them a narrative description of the memorial and what it meant to him.
Yeah. Well, now, one recent aspect of the story is that you're actively raising funds for the completion of the memorial, as you said, Judge. Already, you've secured about a fourth of your $1 million goal.
Yes.
And last month, the committee received two $50,000 donations from St. Louis law firms Thompson Coburn and Gray, Ritter, and Graham.
Right.
Paul, could you give us an update on how fundraising is going and how people can give?
These are very exciting developments, and we are so grateful to both Thompson Coburn as well as Gray, Ritter, Graham. Really shows some great leadership on this wonderful project, this inspiring project. That so basically, though, we take donations of any size. The smallest donation we have is $25. We have a number in the hundreds or $100 range. Other law firms have picked up in the $5,000 to $10,000 range. We have one who's pledged $20,000. It's still a long way to go, but it's been very exciting and it's been very great, especially, this is a challenging time with the pandemic to have people even think about something like this. But what we've tried to impress upon people, and I think they've been pretty readily receiving it, is this is something that the city needs, and not only the city, but the nation does. And so I think it has been something, once people get to see it, I think the video has been very, very helpful. Early on, our fundraising efforts were hampered. And I will say, I did think, I told the committee at one point, I think we need a video, but my idea of a video was not what the Cool Fire Studio people were able to generate, which is a phenomenal piece. I was thinking of a simple 2-minute talking head thing that would try to get enough detail in, and obviously that would have been a miserable failure. So to have Ed Herman help us and to have Cool Fire Studios get in is really, really helpful. It's a great way to convey what this means, for the future of the city and for understanding. And hopefully this will serve, and people see this now with the Learning Center aspect of it, really as a platform to educate even further where the spark of freedom that the Freedom Students Memorial will give people, and to be able to see that spark of freedom, where that led for the struggles of African Americans in American history. And it's still not over, but hopefully this will be a great start for some people who are, like me, I was unaware of these totally until I got involved. Till Judge Mason asked me to be invited, and so I'm very, very happy to be involved. It's changed my way of thinking. It just has. I'll say that it has, in a good way, I think.
Well, and I was wondering if you both could just quickly kind of talk about what you hope this memorial will bring to St. Louis.
I believe it will bring two things: a recognition that our past has, despite everything else, has in it this incredible period where the rule of law was honored, even as it relates to slaves. And I'm looking around and I'm trying to find period. I just want to read this to you. This is what Miss Professor Ann Twitty, professor of history at the University of Mississippi, in her book on this subject, which was published by the Cambridge University Press, she says, and this I think says it all about why we should honor this period. Quote, challenging dominant trends in legal history, before Dred Scott, which is the name of her book, argues that this distinctive legal culture, above all, was defined by ordinary people's remarkable understanding of and appreciation for formal law. That monument tells to all existing St. Louisans that at the time when the nation was discussing and dealing with the question of slavery, here in St. Louis, our courts, our juries, and our judges took the position that the law said if a slave presented the right case, they would be entitled to be released from slavery. And we did it for 57 years. And that, believe me, was highly unique in the United States of America. The second thing is the future. That citizens, jurors, young lawyers, judges in particular, as they walk by it, it is a reminder that equal access to courts and giving everybody equality under the law is what holds our nation together. Now, that's what I believe it's going to stand for.
So I think really what I see in this, one of the things I see is the ability to change. These were change agents because they pushed the envelope, and I think it changed the way people thought about slaves, African Americans, and saw them more and more as people, like we are people, and not just chattel or property. And I think these were people who were brave enough, as the judge said, to risk a lot for not just themselves in danger, but their families, to push forward, to seek freedom, just like the founders of this country sought freedom. But that these individuals had a lot more at stake than I think what we see even in the founders. They really were people who need to be memorialized, and I think also to realize that we can change. That's what I see in it as well, that today we can change the way we think about this and appreciate more their bravery and the fact that they deserve to be recognized.
Once again, our guests have been Judge David Mason and Paul Venker. Thanks for joining us. We'll continue to follow your efforts to build the memorial. I'm Jessica Shumaker for MoLawNow. Thank you.